we are going to discuss parts of Constitution of India. In original Constitution, there were only 22 parts, but now we have 25 parts. How come? So, before going to discuss these parts, I would like to tell you that if we consider Constitution as a book, then parts are just like chapters of the book. Every chapter will have paragraphs. So, paragraphs are just like articles, group of articles within a part of the Constitution, while preamble is prologue or introductory part of the Constitution, while schedules are highlighted, separately listed and marked provisions of the Constitution. So, as far as parts of the Constitution, to begin with, part 1 remains intact since 26 January 1950. So, part 1, that is from article 1 to 4, is union and its territory. Union and its territory. So, if we discuss all those 4 articles, they are dealing with the same topic. That is article 1, that is India, that is Bharat will be union of states, not federation of states. Article 2, external reorganization. Article 3, internal reorganization. And article 4, by simple majority, reorganization would be done. As far as part 2 is concerned, that deals with the citizenship. As you know, citizenship involves full and equal membership of a political community with corresponding rights and duties. So, political rights are exclusive with the citizens, and it is from article 5 to article 11. As you know, articles are just like paragraphs of a chapter, and every chapter will have the title. This is just like title, and these articles, that is group of paragraphs, constitute a whole part of the Constitution. So, primarily first 4 parts up to 4A, including preamble, represent principles, values, desirabilities and noble objectives of the Constitution, while from part 5 onwards, that is part 5 is union government, institutions are being mentioned. Without institutions, principles will remain in air, and without principles, institutions will be directionless. So, both principles and institutions are complementary. As far as part 3 is concerned, it is fundamental right. It is one of the most important part of the Indian Constitution. Preamble along with part 3 and part 4 is called core and conscience of the Constitution. So, fundamental rights, it is from article, fundamental rights. So, it is from article 12 to 35, and it includes 6 kinds of rights, namely right of equality, right of freedom, right against exploitation, religious rights, educational and cultural rights, remedies. In original Constitution, right to property was fundamental right under article 19(1)(f) and 31. However, thanks to 44th Constitutional Amendment 1978, by which it was shifted to 300A, so it's now only a legal right, legal constitutional right, no more a fundamental right. So, you must be knowing the difference between legal right and fundamental right. First of all, fundamental right can be amended only by 2/3 majority, while legal right can be amended by simple majority as well. Second, in case of fundamental rights, it is available both against executive and legislature, while legal right is only available against executive, not against legislative laws. And thirdly, for fundamental rights, protection and guardianship is done by higher judiciary, namely Supreme Court under article 32, and high courts under article 226 through writ jurisdiction, which is not the case with ordinary right or legal right. As far as part 4 is concerned, that is DPSP, that is Directive Principles of State Policy. that is from Article 36 to 51. So, policy making is with the state. Now we have Niti Aayog, more institutionalized policy making. But for policy making, constitution, the supreme law, gives direction, and those directions has to be kept in mind before framing law. So, DPSP mainly consists of community rights to be enabled by the state, while Part 3 mainly consists of individual rights against the state. In original constitution, there was no Part 4A. 4A and 14A were added by 42nd Constitutional Amendment 1976. So, Part 4A was added by 42nd Constitutional Amendment with Article 51A, that is fundamental duties of citizens. So, 10 duties were provided in 1976, while 11th duty was provided by 86th Constitutional Amendment 2002, that guardians have the fundamental duty to send their child for elementary education of age group 6 to 14. So, this is Part 4A. So, next part, now Part 5 onwards are the institutions. So, Part 5 of Constitution of India is from Article 52 to 151, that is union government. So, government at the union level is most important institution for implementation of those principles and values. So, every government will have 3 branches. Here also executive is from Article 52 to 78. Legislature, that is parliament, is from Article 79 to 122. Ordinance making under 123. Supreme Court under Article 124 to 147, and CAG, Comptroller and Auditor General, from Article 148 to 151. Although CAG is listed in union government, but there is only one CAG for the whole India. It's not that one CAG for center and another CAG for state, another CAG for local government. No, there is one CAG, one guardian of public purse. Then next important institution in order is Part 6, that is state government. State government, that second tier of the government, from Article 152 to 237. In original constitution, there were 3 categories of states, A, B, C, while D was union territory. A were those states where mainland states where democracy was prevailing. B was stronger princely states, C were weaker princely states, and D was Andaman Nicobar. However, by 7th Constitutional Amendment, all states were listed in Part 6 and all UTs in Part 8. So, now there is no A, B, C, D category of states. All states, uniform states in Part 6, all UTs in Part 8. As far as Part 7 is concerned, as I said, A, B, C, D category. So, B category of states has been done away with, 238 also done away with, 242 also done away with. So, Part 7 is blank. So, if anybody is asking you what is there in Part 7 of the Indian Constitution, you can say now nothing. It is blank. Why it is blank? Because B category of states were done away with and other parts were not shifted, otherwise every now and then the order will change. As far as Part 8 is concerned, that is union territory. As the name suggests, union territories are directly administered by the central government, 239 to 241. So, in 1956 there were 6 union territories, now we have 8 union territories, 28 states and 8 union territories. And Part 9 was also done away with in 1956, as C category of states were also done away with. But Panchayati Raj was included by 73rd Amendment in Part 9A, 9, from Article 243 to 243O. That is Panchayati Raj institution, PRIs. By 74th Amendment, Part 9A were added, that is Nagar Raj Institution, from 243P to 243ZG. Cooperatives were added by 97th Amendment in Part 9B. So, Part 9B. So, cooperatives were added very late, but it were included in also in fundamental right in 191C, DPSP 43B, here also 243ZH to 243ZT. As far as Part 10 is concerned, that is scheduled area. Area approach is followed for STs. So, there are two kinds of scheduled areas. One is 244(1), while the tribals of Assam, Meghalaya, Mizoram, Tripura, who are slow in adapting mainstream life, they have more autonomy under Schedule 6 or to Article 244(2). Both are covered under Part 10. As far as Part 11 is concerned, I always say that 11 is 5 plus 6. So, a student of mathematics may say, no, 9 plus 2 is also 11. Why you are saying 5 plus 6 is 11? There is a reason. Part 5 is union government, Part 6 is state government, and union-state relationship is in Part 6, Part 11. 5 plus 6 is 11. So, union-state relation, legislative relation, executive relation and administrative relation from Article 245 to 263. That is union-state relationship in Part 11. As far as union-state financial relation is concerned, that is there in Part 12, 10, 2. Financial relation from 264 to 300A. Financial relationship is there in this part. As far as trade and commerce is concerned, that is in Part 13. Again, it is mainly concerned with the interstate trade and commerce. So, it is inspired from Australian Constitution and it is from Article 301 to Article 307. As far as Part 14 is concerned, that is services. When we say services at the union and state level, that means bureaucracy, that means permanent executive. Because executive cannot run on one wheel of political executive. Political executive owes its position to the mandate, while bureaucracy owes its position to the merit. So, Part 14 is services at the union level and state level, 308 to 323. And as I said earlier that by 42nd Amendment, 4A and 14A were added. So, 14A, tribunals to deburden judiciary. 14A, here two kinds of tribunals are there, 323A, administrative tribunals, and 323 other tribunals. So, this is there in Part 14A. As far as Part 15 is concerned, this was very much in news because of the recent change by the government in which CGI would be removed from the committee which will recommend for appointment of election commission members. So, Part 15, 324 to 329, and Part 15 cannot be seen in isolation, it has to be read along with Representation of People's Act, RPAs. RPAs are very much important in UPSC and state PSC as well. So, this is constitutional provision and RPAs, that is Representation of People's Act, they are statutory. Statutory provisions are those which are formed by Act of Legislature. As far as Part 16 is concerned, the whole mandate of Part 16 is derived from Article 46 of Indian Constitution as well as Article 16(4) of the Indian Constitution. So, it is always said that Part 16 should be read along with Article 46 and Article 16(4) of the Indian Constitution. So, this is there for weaker sections, SCs, STs, OBCs, women and now EWS as well. So 330 to 342, this is for social justice primarily, and for weaker sections, positive discriminations in favor of weaker sections. As far as part 17 is concerned, part 17 consists of official language. Part 17. So when we say official language, it is not only official language of the Union. First two articles, 343 to 344, they are official language of Union. Then next three articles are official language at the state level. So this is from 343 to 351, official languages. Official language is the language in which the government work take place, official work take place. So at Union level, it's only Hindi and English which is official language, but at state level, ample autonomy have been given to states to declare official language at the state level. So as far as part 18 is concerned, that is emergency provision, that is inspired from German constitution. All the three kinds of emergency, 352 national emergency, 356 president's rule, and 360 financial emergency. So this emergency provision to take up the extraordinary situation. As far as part 19 is concerned, that is miscellaneous. Miscellaneous from 361 to 367. 361 has been asked so many times in exam. Immunity to president and governor from all criminal and civil cases. So these are the privileges and exceptions to Article 14. As far as part 20 is concerned, that is the only part that the name of which has been changed. In original constitution, the name of it was constitutional amendment, but by 24th and 25th amendment, the name of part 20 was changed to power of parliament to amend the constitution under Article 368, which is called constitutional amendment, to be different from simple amendments. Simple amendments are not deemed to be called constitutional amendment, but constitutional amendment under Article 368 in part 20 is done by 2/3 majority of both houses of parliament. So these are substantive amendments, substantive changes. As far as part 21 is concerned, this is from 369 to 392. So that is temporary, transient and special provisions. It also included 370, which provided special status to Jammu and Kashmir till 4th August 2019, but special status was done away with through presidential order on 5th August and next presidential order on 6th August, and in the meantime reorganization was done. Now Jammu and Kashmir is union territory under Article 239A, just like Delhi. So part 22, that is short title. This constitution can be called Constitution of India. Then the date of commencement is there and termination is there, that all British laws would be terminated to ensure sovereignty and suzerainty of the country. So I just conclude that in original constitution there were 22 parts. However, by 7th constitutional amendment, part 7 and part 9 were done away with. So by 7th constitutional amendment 1956, these two parts were done away with. So number of parts of the constitution reduced to 20. Again, by 42nd constitutional amendment, two more parts were added, 4A and 14A. So that was 42nd constitutional amendment 1976, 4A for fundamental duties of the citizens and 14A for tribunals. So again it became 22. But again two more parts were added by 73rd and 74th Constitutional Amendment 1992, Panchayati Raj Institution and Nagar Raj Institution. So total number of parts in 92 became 24, and one more part was added, cooperatives, by 97th Constitutional Amendment 2012. So cooperatives were added in 9B. So now total number of parts of Indian Constitution is 25. So in brief, we have seen the whole Constitution. Thank you.